Good morning. I'm in the middle of a trial. We're on lunch break. I got about another 15 minutes to kill, and I'm on the petitioner side about the rest. So I've just gone through and made sure that I've covered all the points I need to cover. Now I have time to kill because I'm a fat man on a fat man diet, and so I just eat keto foods. No carbs, all protein and fat in my car, like a fatty, like fats a lot, because I've been on keto now I took a week off for Christmas, and I took, not really the day off for my birthday, but I did have a piece of pie on my birthday, because, fatties like pie, and I'm a fatty and I love pie. I remember a commenter accused me of being diabetic and with hypertension. Sadly for him, I'm neither. I don't eat nearly enough carbs to be diabetic. But anyway, that's neither here nor there. So I got time on my hands, and I figured I'd talk about the DMA versus fraud or troll case. Now, you're going to say, John, you don't talk about copyright. I know, and I don't have to talk about copyright to talk about this case, because I don't understand copyright. And I don't want to learn it. I mean, I don't know enough to comment on it with any authority. So, I try to maintain my humility and not pull, what's his name? RC, and talk about shit I have no idea about. That guy cracks me up. Anyway, I don't watch it, but the things that he's done have cracked me up in the past. So, apparently, Fraud or Troll, his attorney filed a motion to dismiss. A motion to dismiss basically says, based on the pleadings, if everything that is alleged in the complaint is true and correct, then we still win. So let's just stop it here, right? That's a motion to dismiss. Well, they filed it for counts 2, 4, or causes of action 2, 4, and 6. No, 2, 3, and 4. 2, 3, and 4. I'll get there someday. My head's still on the trial. Sorry. And the court denied it as to counts or causes of action 2 and 4, granted it to 3. 3 is declaratory relief. I don't know why you need to plead declaratory relief. Again, this might just be my ignorance on copyright matters. Declaratory relief, every time I've pled for it, has just been basically for the court to say, you're right, they're wrong. That's it. There's no money associated with it. It's just a cause of action to get the court to say you're right. That's it. No money associated with it other than whatever attorney's fees you've paid. And maybe there's an attorney fee recovery for it. Maybe that was the angle. I don't know. So maybe I should shut up about it and stop guessing. So Fraud or Troll won on the declaratory relief, but lost on the other two. So it's kind of a Pyrrhic victory. He spent a lot of money. It's a boutique attorney. My best guess is that boutique attorney is charging somewhere between $750 and $1,000 an hour, maybe more, probably not less. U.S. money, not Canadian loonies or whatever they call them. And he's gotten really no results so far. Really no results. I mean, winning on the declaratory relief might feel good. He's probably hyped it up to Fraud or Troll. He's probably hyped it up to his fans as a real big win. But I don't think so. And again, I could be wrong, but I don't think so. The ones you got to watch out for are the ones where there's dollars associated with them, where there's actual money, where you could be paying DMA. And I think the last thing Fraud or Troll wants to do is pay DMA. And the thing that DMA is probably least worried about is declaratory relief. And again, I'm not saying the DMA is going to win, but so far, Fraud or Troll really hasn't gotten anything from his money. And he spent a lot of money. How much exactly he spent, I don't know. But it's at least a lot. The $30,000 might have been Canadian. I don't know. I don't care. It's still a lot of money, right? I don't know about you, but I'm not dropping 20, 30 grand on the floor and not turning around to pick it up. You know what I mean? So, why am I talking about this? Well, I'm talking about it because of what the court said in denying counts 2 and 4. And the court basically represented that Fraud or Troll's attorney was grossly misunderstanding things, cases, case law, and the current facts and allegations, and indeed went so far as to cite a case that didn't exist. Well, first of all, they cited a case that they said stood for the proposition that they should win on a motion to dismiss. Apparently, Randy pointed out that, in fact, that case dealt with motion for summary judgment, not motion to dismiss. Summary judgment comes after discovery generally. It takes in, okay, if every contested fact is taken in the non-moving party's favor, and if every agreed upon fact is taken into consideration by the court, just the contested facts by the non-moving party and the agreed upon facts, the moving party still wins. That's what a motion for summary judgment is. Replay that as many times as you need to understand it. But that comes after discovery. That's when you know what facts you have that you agree with, what facts you have that you don't agree with, and that's when a motion for summary judgment is appropriate. So his attorney didn't understand when he first argued in the motion papers that this case was an apposite. Randy pointed out it was an apposite. It didn't apply. It was a different procedural issue that this particular case was dealing with. Then the boutique attorney acknowledges it in the reply brief, but then argues it again anyway. Like, what world does that make sense in? I don't know. Hard to make sense of. Hard to understand why a high-profile attorney with apparently hundreds of wins in copyright and even more copyright cases would make such an error. It seems odd. But then the coup de grace, for me, was a citation to a Second Circuit case that doesn't exist. Doesn't exist. No such case exists. The court couldn't find it. If the court couldn't find it, it doesn't exist. Now, what do you know of that spits out bad citations to cases that don't exist? The only thing I know of is AI. Is Fraud or Troll paying hundreds or maybe $1,000 an hour, like $750 to $1,000 an hour to an attorney to feed stuff into AI and hope he gets a good result? Well, he's not getting a good result. That's just some sloppy nonsense. I am just shocked. I am shocked. In this particular situation, while Randy may have less credentials, and while Randy is certainly not a well-organized attorney who writes great pleadings or anything like that, he's been the better attorney so far. And I don't like Randy. I mean, I'm not saying this because I want to, fluff him up or anything. I don't like the guy. I banned him from my Discord. I don't like the guy at all. But he's the better attorney. I mean, I calls him like I sees him. He's the better attorney so far. So it's just interesting to me, I hope that Fraud or Troll's attorney hasn't puffed up this seemingly meaningless victory on count 3 too far. I hope he's not touting it as a victory. I hope he's not misleading his client. I hope he's not using AI. I mean, well, either your choice is either you're just a fuck up and like you're putting dumb shit in your pleadings, thinking the court isn't going to catch it. Federal courts catch it, by the way. Just FYI, federal courts catch it. You don't sneak shit past a federal court. So either he's stupid, or he's using AI and he's not double checking his work. I mean, like, where's the positive spin you could put on it? I don't see it. I mean, if someone knows the positive spin you could put on it that makes this boutique attorney not a fuck up, let me know. But I don't see it. I don't like it when attorneys paint the profession in a bad light, and that's all I could see from this guy. Anyway, I saw my client drive in, so I'm gonna have to go and calm my client down and all that fun stuff. But anyway, that's all I got for you today. Thanks for watching. Have a great day.